He spent his career putting killers behind bars. And then the police decided he was one. Picture this: a prestigious Perth neighborhood, a winter morning in 2007, and a woman who hasn't come home. Corryn Rayney, sharp-minded lawyer, devoted mother of 2 daughters, simply vanishes after a beginner's belly dancing class. No struggle, no witnesses, no goodbye. Now here's what makes this case unlike anything Western Australia has ever seen. The man police would eventually name as their prime suspect wasn't a shadowy stranger or a career criminal. He was one of their own, in the sense that mattered most. Lloyd Rayney sat at the highest rungs of the state's legal establishment, a senior Crown prosecutor with a kind of courtroom reputation that made defense lawyers nervous before a trial even began. And what you're about to see, the forensic evidence planted inside a family home, the audacious move police made that had never been tried before in Australian legal history, and the decade-long legal battle that followed, will change how you understand the phrase beyond reasonable doubt. Later in this video, the discovery that stopped investigators cold inside a Perth park. The recorded phone calls that prosecutors said told a story all on their own. And the courtroom moment that handed Lloyd Rayney back his freedom, while leaving a family without a single answer that truly satisfies. Because here is the question that sits at the heart of this entire case, the one no court has ever definitively resolved. If Lloyd Rayney didn't do it, then who did? And if he did, how did he walk free? Stay with this, because by the time we reach the end, you will understand exactly why this case has haunted Western Australia for nearly 2 decades, and why it probably always will. Perth, Western Australia, sits at the edge of the world, literally. It is the most geographically isolated major city on Earth, a sun-drenched coastal metropolis of just over 1 million people in 2007, where the legal and social elite moved in circles that were small, tight, and keenly watched. It was in this world that Corryn Rayney built her life. Born Corryn Laxton, she was by every account a woman of exceptional intelligence and warmth. She had pursued law with a kind of deliberate ambition that doesn't apologize for itself, eventually becoming a registrar of the Supreme Court of Western Australia, a position of genuine authority and institutional weight. She was not a background figure. She was precise, professionally accomplished, and widely respected among colleagues who knew how demanding the work was. But the people who remembered Corryn most vividly didn't describe a title or a courtroom. They described a mother. She and Lloyd had 2 daughters together, both primary school-aged in 2007, and those who knew the family said Corryn was present, attentive, and fiercely devoted to the girls in the way that only parents who genuinely enjoy their children tend to be. The couple lived in Corryn Street, South Perth, a quiet, leafy suburb where the houses are well kept and the street noise is mostly birdsong. South Perth sits across the Swan River from the city centre, close enough to the urban core to feel connected, but residential enough to feel removed from it. It was the kind of address that signaled a certain kind of success, established, professional, settled. Lloyd Rayney had earned that address. A senior Crown prosecutor with the Western Australian Director of Public Prosecutions. He was a formidable legal mind. In a city where the legal community is small enough that most senior lawyers know each other by first name, Lloyd's reputation was significant. He was experienced, methodical, and authoritative, qualities that served him well in court and that shaped, by all appearances, a highly ordered domestic life. But by 2007, that domestic life was fracturing. Lloyd and Corryn were in the process of separating. Their marriage, whatever its earlier shape, had deteriorated to the point where divorce proceedings were underway. The specifics of their private disputes, financial arrangements, custody of the daughters, the division of a shared life, were known only to those closest to them and to the family lawyers now involved. What can be said is that their separation was neither simple nor amicable. People who knew the couple in this period described a relationship that had become adversarial. Corryn had reportedly confided in people close to her about her concerns during this time. The precise nature of those concerns, what she said, to whom, and how explicitly, would later become critical to the investigation. It is also worth noting that Corryn was not simply a passive party in the separation. She was a trained legal professional who understood the system she was navigating. She knew her rights. She was not, by any characterization, a woman who did not know how to assert herself. On the evening of Thursday, the 2nd of August, 2007, Corryn Rayney attended a beginner's belly dancing class at the Bentley Community Center, something she had apparently started as a personal outlet during a difficult period. The class was a small, informal group. She attended, she participated, and at the end of the evening, she left. She was seen walking to her car in the car park. After that moment, Corryn Rayney was not seen alive again. When she did not return home that night and failed to make contact the following day, those who expected to hear from her grew concerned. Corryn was not the kind of person who simply disappeared. She was organized. She had daughters to get to school. She had a schedule, and yet nothing. The silence that followed that belly dancing class was not the comfortable silence of a woman who had stepped away for a weekend. It was the wrong kind of silence. The kind that makes the people who love you reach for the phone with a tightening in the chest they cannot quite name. Perth was about to discover that it had lost one of its own, and that the investigation that followed would turn the entire city's understanding of trust, law, and justice inside out. The missing person report was filed on the 3rd of August, 2007, the morning after Corryn failed to return from her belly dancing class. Police began initial inquiries. At this stage, they were looking for a missing woman. The possibility that something criminal had occurred was present, but unconfirmed. What happened next unfolded quickly. On the 7th of August, 2007, 5 days after Corryn was last seen, her body was discovered in Kings Park. For those unfamiliar with Perth's geography, Kings Park is one of the largest inner-city parks in the world. Over 400 hectares of bushland, botanical gardens, and walking trails that overlook the Swan River and the city skyline. It is a beloved landmark. Families picnic there on weekends. Tourists photograph the wildflowers. War memorials stand quietly in the older sections. It is not a place associated with violence. Corryn's body had been buried in a shallow grave in a section of the park's bushland. She was discovered by a parks worker. The burial was not deep, the kind of concealment that suggested urgency rather than premeditation, or so investigators initially considered. It was not the work of someone with time on their hands and a careful plan executed over days. It appeared to be faster than that. Corryn had been wrapped in a sheet. The forensic examination that followed determined that she had been killed as a result of compression to the neck, strangulation. The Western Australian state coroner and forensic pathologists working the case would establish this as the cause of death. Corryn Rayney had been strangled, then transported to Kings Park, and buried in ground that was dry and hard in the Perth winter. The site where she was found was not far from roads and access points. Someone who knew Kings Park, its quieter sections, its less trafficked areas, might have known where to go. Or it may have been the kind of discovery made under pressure by someone acting quickly in a city they knew well. Investigators immediately began working backwards from a last confirmed sighting, the belly dancing class at the Bentley Community Center on the night of the 2nd of August. Other students at the class confirmed Corryn had attended. She had seemed, by accounts, ordinary, not visibly distressed, not hurried. She left as the class wound down. CCTV footage later reviewed from the area placed her car leaving the community center car park. After that, the trail went cold in terms of eyewitness accounts. There was no confirmed sighting of Corryn alive beyond the car park. Investigators began reconstructing the hours between the class's end and the estimated time of her death. The forensic evidence suggested she had not died at Kings Park. The gravesite was almost certainly not the location where she was killed. She had been killed somewhere else, then moved. This was a critical piece of information. It meant there was a primary crime scene that had not yet been identified. It meant someone had transported a body across Perth in the middle of the night, or in the early hours of the morning. In August in Perth, the nights are cool and dark early. Traffic thins significantly after midnight. The logistics were grim, but not inconceivable. Not for someone who knew the city and remained calm enough to execute each step without drawing attention. The Corey Stein Street family home, where Lloyd Rayney still resided and where the two daughters were, came into focus almost immediately. Police approached the house, and what they found inside would become one of the most discussed forensic details of the entire case. Inside the Rayney home, forensic investigators located a series of small yellow forensic marker cards, the kind used by police to flag evidence at crime scenes. These were not cards the police had placed. They had been placed by someone who had apparently obtained them and positioned them at points within the house. Their significance, what they marked, what they were intended to indicate, or whether their presence was innocent, was never publicly established beyond ambiguity. The discovery deepened the unease around the investigation. This was not a typical missing person case that had become a homicide investigation. This was something stranger. And at the center of it all was a man who knew the criminal justice system, as well as the detectives now watching him very, very closely. The homicide investigation into Corryn Rayney's death was one of the most intensive ever mounted by Western Australian police. From the earliest stages, Lloyd Rayney was what investigators call a person of interest. This was not unusual. In cases of domestic homicide, which this appeared to be, the immediate family circle is always the starting point. Statistically and investigatively, it is the correct place to begin. What made this case different was the identity of the person at the center of that circle. Here was a senior Crown prosecutor, a man whose professional life consisted of building cases against accused murderers, a man who understood, at a granular level, exactly how homicide investigations worked, what police looked for, how evidence was interpreted, what forensic mistakes left trails. If Lloyd Rayney had killed his wife, he would have done so knowing more about how to avoid detection than almost any layperson in Australia. That was the double-edged reality investigators faced from day one. Police began compiling their case methodically. One of the most significant developments came through telephone intercepts. Australian law enforcement agencies can, under warrant, intercept telephone communications, and police had obtained authorization to monitor calls involving Lloyd Rayney. The recordings captured conversations that, according to investigators, were significant to the case. Without detailing their full content, much of which was subject to legal suppression orders over the years, it can be said that these intercepts formed part of the prosecution's eventual case and were used to suggest state of mind and behavior in the period following Corryn's disappearance. Forensic investigators focused heavily on the Corryn Street home. The house was examined in extraordinary detail. Soil analysis played a central role. Specifically, whether soil consistent with the Kings Park burial site could be found in connection with the property or items associated with Lloyd Rayney. Forensic experts examined footwear. They examined clothing. They examined the garden. Every surface of a family home became a potential data point. The investigation also turned to Lloyd Rayney's professional life. Colleagues were interviewed. His movements on the night of the 2nd of August were scrutinized. Investigators examined whether there were financial motives. The divorce proceedings had, according to those familiar with the case, become increasingly contentious by 2007, with significant assets potentially in dispute. The broader context of the Rayney's marriage breakdown was explored in detail. Corryn had reportedly consulted a solicitor about her situation. She had, by some accounts, expressed apprehension about aspects of her circumstances. These fragments, individually inconclusive, collectively suggestive, contributed to the picture investigators were building. Then came a decision that had no precedent in Australian legal history. On the 22nd of August, 2007, just over 2 weeks after Corryn's body was found, Western Australian Police called a press conference. At that press conference, Detective Senior Sergeant Jack Lee made a public statement that stunned the legal community. He named Lloyd Rayney as the prime suspect in his wife's murder. He used those words, prime suspect, publicly, before any charges had been laid. Lloyd Rayney was not a private citizen. He was a serving officer of the court, a prosecutor. The public naming of a suspect before charge in this context was unprecedented, and Lloyd Rayney's response was equally unprecedented. He sued the Western Australian Police Force for defamation. That civil case, running alongside the criminal investigation, added a layer of legal complexity to the entire proceeding that had no real equivalent in Australian criminal history. Lloyd Rayney was simultaneously a suspect in his wife's murder and a plaintiff in a defamation action against the police investigating him. The criminal investigation continued for years. It was not until the 14th of December, 2010, more than 3 years after Corryn's death, that Lloyd Rayney was formally charged with the willful murder of his wife. The charge was the most serious available under Western Australian law. The committal proceedings and subsequent trial preparation were meticulous. The state had built a case that was, by any measure, circumstantial, in the sense that there was no single piece of direct evidence, no eyewitness to the killing, no confession. What the prosecution had was a constellation of forensic evidence, timeline reconstruction, motive arguments, and the recorded phone calls. The defense, predictably, contested every element. The trial itself began in 2012 before Justice Brian Martin, sitting without a jury. In Western Australia, accused persons in certain cases can elect to be tried by judge alone, without a jury, and this is what occurred. Every piece of evidence was examined. Expert witnesses were called and cross-examined. Forensic specialists debated the soil analysis. The telephone intercepts were scrutinized for context and interpretation. Lloyd Rayney took the witness stand in his own defense. The trial ran for months. It was exhaustive. And then Justice Martin delivered his verdict. On the 11th of June, 2012, Justice Brian Martin acquitted Lloyd Rayney of the willful murder of Corryn Rayney. Not guilty. The verdict landed in Perth like something heavy dropped from a height. Justice Martin delivered a detailed judgment, over 300 pages, that went through every piece of evidence the prosecution had presented and found, ultimately, that the state had not proven its case beyond reasonable doubt. The forensic evidence, while suggestive in places, was not conclusive. The timeline had gaps that the defense had successfully exploited. The circumstantial case, in the judge's assessment, did not reach the threshold required for a criminal conviction. Lloyd Rayney walked out of court a free man. He had been acquitted of murdering his wife. He had spent years under the weight of Australia's most scrutinized criminal case. And he had, in the eyes of the law, done nothing proven. But the legal proceedings were not entirely over. His civil defamation action against the Western Australian police force, initiated after Detective Senior Sergeant Jack Lee publicly named him as prime suspect in 2007, had continued through the criminal proceedings. In 2015, Justice Antoinette Kennedy ruled in Lloyd Rayney's favor on the defamation claim. She found that the public naming of Lloyd Rayney as prime suspect before charge had been defamatory. He was awarded damages. It was a moment without easy interpretation. A man acquitted of murdering his wife had now also won a defamation case against the police who investigated him. Western Australia's legal establishment was left contemplating the implications of both outcomes simultaneously. The case's impact on Western Australia is difficult to overstate. For the Western Australian legal community, the Rayney case became a landmark study in the limits of circumstantial prosecution, a reminder that the machinery of a state, however confident, must still meet the standard of proof, and that standard exists for reasons that apply equally to prosecutors, police officers, and everyone else. It prompted internal discussion within the DPP's office about how cases involving professionals with legal knowledge should be handled. For the broader public, the case exposed something more uncomfortable: the gap between what people believe happened and what the law can prove. Many in Perth, perhaps most, formed their own conclusions. Those conclusions varied. They still vary. The question of what actually happened to Corryn Rayney on the night of the 2nd of August, 2007, remains, in any formal legal sense, unanswered. No one has ever been convicted of her murder. No alternative suspect has ever been charged. Corryn's family, including her parents and her brother, have spoken over the years about the toll the case took on them. Not only the grief of losing Corryn, but the grief of watching a decade-long legal process conclude without what they would consider justice. Their daughter, their sister, was killed. Someone buried her in Kings Park. And the court system, the very system Corryn herself had served, did not produce a conviction. The Rayney daughters, who were young children when their mother died, grew up in the shadow of this case in ways no child should have to. Their lives bifurcated at the moment their mother did not come home from a belly dancing class. Everything that followed, the news coverage, the trial, the public debate, unfolded around them as they moved through school, through adolescence, through the years. Lloyd Rayney returned, eventually, to legal practice. His professional life had been fundamentally altered by the case. His role as Crown prosecutor ended in the aftermath, but he resumed work as a solicitor in subsequent years. The case periodically reemerges in public conversation. There have been documentary treatments, long-form journalism, podcast discussions. Each time, the same questions surface. Each time, no new answers are produced. What the Rayney case ultimately leaves behind, beyond the legal record, beyond the headlines, is a more unsettling thing. It is a case that tested and found wanting the certainty that truth and legal outcome are the same thing. It revealed how much space exists between what a community believes and what a courtroom can establish. It showed how the machinery of justice, applied rigorously and in good faith, can still produce an ending that feels, to the people most affected, like no ending at all. Corryn Rayney was 44 years old when she died. She was a mother. She was a lawyer. She was someone's daughter, someone's sister. She had gone to a beginner's belly dancing class on a winter Thursday evening, walked to her car, and disappeared. She deserved better than the question that still hangs over Kings Park. She deserved an answer. He spent his career helping criminals go free, until the day he decided to become one. Picture a Sunday morning in November, the kind of morning that feels ordinary in every possible way. Two young boys are buckled into the back seat of a car. Their mother is driving. The neighborhood is quiet. The trees lining the road still carry a few last leaves from autumn. And then a man steps out from the shadows, and everything changes. Within minutes, Sarah Tokars is dead. Her sons have witnessed something no child should ever have to see. And somewhere across the state of Georgia, their father, a well-dressed, well-connected criminal defense attorney, is waiting for a phone call confirming that it is done. Here's what you need to know before we go any further. Frederick Tokars was not a man living on the margins. He was a man at the center of everything: the courtrooms, the country clubs, the political fundraisers. What investigators would eventually uncover wasn't just a murder. It was a hidden empire, one built on dirty money, dangerous alliances, and a web of deceit that stretched from the Atlanta suburbs into the heart of the American drug trade. The two boys in that back seat? They survived. And what they saw that morning would become the most devastating evidence against their own father. And the hitman? He didn't disappear. He talked. But before any of that, before the wiretaps, the informants, the federal indictments, and the courtroom that packed wall to wall for weeks, there was Sarah. There was a woman with a life worth living, a marriage slowly rotting from the inside, and a secret she had begun to suspect that her husband would do anything to keep buried. The question is not simply who killed Sarah Tokars. The question is why, and how far a man will go when the truth threatens to undo everything he has spent his life building. Stay with us, because this story is far stranger, far darker, and far more calculated than you have been led to believe. Sarah Ambrusco was, by every account of those who knew her, the kind of person who made a room feel warmer just by walking into it. Born into a close-knit family in Cuyahoga Falls, Ohio, Sarah grew up with a strong sense of loyalty and a quiet but firm belief that the people you love should be protected at all costs. She was bright, socially graceful, and possessed an easy warmth that people noticed immediately. Friends described her as someone who listened when others spoke, genuinely listened, and who had an instinct for making people feel seen. She moved to Atlanta in the 1980s during a period when the city was expanding rapidly, drawing ambitious young professionals from across the country. It was in this environment that Sarah crossed paths with Frederick Tokars. Frederick was exactly the kind of man who looked like a success story. He had the credentials, a law degree, a growing practice, a name that people in Atlanta legal circles were beginning to recognize. He was charming in the way that lawyers are sometimes trained to be, and he projected confidence with the ease of someone who had never seriously doubted himself. They married. They built a home in Marietta, Georgia, an affluent suburb northwest of Atlanta, in a neighborhood of manicured lawns and two-car garages where the assumption was that everyone had made it, or was close to making it. Sarah became a mother. First one son, then a second. She poured herself into the role with the same warmth she brought to everything. Those who knew her during those years remember a woman who was genuinely present at birthday parties, at school events, at neighborhood gatherings. She was not performing contentment. She appeared to the people around her to be living it. But behind the front door of that Marietta home, the picture was more complicated. By the early 1990s, those who were close to Sarah had begun to notice subtle signs of strain. She was quieter at times, occasionally distracted. There were moments when her friends sensed something she wasn't quite saying, a weight she was carrying that she hadn't yet found the words for, or perhaps hadn't yet decided whether to share. What Sarah Tokars had slowly come to understand, or at least to suspect, was that the man she had married was not entirely who he appeared to be. Frederick Tokars had built a respectable public identity. He was a former assistant district attorney in Fulton County, which gave him not only legal expertise, but genuine insight into how prosecutors think and how investigations are run. He had transitioned into private practice and cultivated a reputation as a defense attorney, someone who understood the system from both sides. He was also, at various points, politically connected, moving in the kinds of circles where introductions lead to opportunities and favors are quietly exchanged. But beneath that surface, Frederick had made a different set of choices entirely. Investigators would later establish that Tokars had become deeply involved in laundering money for drug traffickers. The operation was not amateurish. It ran through nightclubs and cash-intensive businesses that could absorb large sums without drawing immediate suspicion. Tokars allegedly used his legal expertise to structure transactions and shield the movement of illegal proceeds, bringing a professional sophistication to an enterprise that was, at its core, a criminal one. Sarah was beginning to see pieces of this picture. Exactly how much she knew, or how close she was to acting on what she knew, remains a matter that investigators would work to reconstruct in the months following her death. But this much is documented. She had consulted with at least one attorney about the state of her marriage. She was asking questions. She was, quietly, preparing for something. On the evening of November 28, 1992, the Sunday after Thanksgiving, Sarah loaded her two sons, ages 4 and 6, into her car. They were returning home after visiting her sister-in-law's family. It had been a holiday weekend in the most ordinary sense, family food, the kind of easy company that makes November feel warmer than it is. She was on Ackworth Due West Road in Marietta when the evening stopped being ordinary. The sequence of events that night has been reconstructed through witness testimony, physical evidence, and most critically, the account of the two young boys who were present in that car. Sarah Tokars had pulled the vehicle over, or been forced to stop, in the area of Ackworth Due West Road. What happened next unfolded quickly. A man approached the car. His name was Eddie Lawrence. He was not a stranger to Frederick Tokars. He was a contact within the criminal network Tokars had been operating inside of, a man with a history of violence and a specific reason to be on that road at that moment. Sarah was shot. The wound was fatal. She died at the scene. Her two sons, 4-year-old Rick and 6-year-old Andy, were in the back seat of that car when it happened. They were physically unharmed. But what they had seen, and what they would be able to describe, would become one of the most important elements of the case that followed. Lawrence fled the scene. The boys remained in the car with their mother until help arrived. When authorities responded, they found a scene that presented, at first glance, as a potential carjacking or a random roadside attack. Marietta, at that time, was not a high-crime area. The neighborhood where this occurred was exactly the kind of place where violent crime was rare enough to be genuinely shocking. The working assumption in the immediate hours after the discovery was that Sarah Tokars had been the victim of a crime of opportunity, a robbery gone wrong, a moment of terrible misfortune on an otherwise quiet Sunday evening. That assumption would not survive the investigation. Meanwhile, Frederick Tokars received word of his wife's death. His response, and the particular details of his behavior in the hours and days that followed, were noted by those around him. He had been out of state that weekend, in Florida, a fact that would later be examined closely as investigators tried to establish a precise timeline of events and communications. The funeral drew people from across Atlanta's professional and social networks. Frederick Tokars appeared as a grieving widower. He was seen, he was present, and he played the role that was expected of him. But the investigation was already beginning to move in a direction that would complicate that performance significantly. Sarah's family, particularly her parents and siblings in Ohio, were not satisfied with early accounts of what had happened. They had known Sarah. They had, in the final months of her life, observed a woman who was worried, who was cautious, who had said things in passing that now, in retrospect, carried a weight they had not fully appreciated at the time. They pressed. They asked questions. They made clear to anyone who would listen that they did not believe their daughter and sister had died randomly. And they were right to push. Because the more investigators looked at the circumstances surrounding Sarah Tokars's death, her marriage, her husband's finances, the nature of his legal clients and business associations, the more the picture of a random roadside killing began to fall apart. This was not chaos. This was planning. Someone had known where Sarah would be that night. Someone had arranged for Eddie Lawrence to be on that road at that moment. And the intersection of that knowledge with the particulars of Frederick Tokars's situation, his financial entanglements, his fear of exposure, his wife's growing awareness of what he was involved in, pointed in a direction that investigators could not ignore. The case was about to become something much larger than a murder. The Cobb County Police Department opened the investigation into Sarah Tokars's death with the standard framework applied to violent roadside incidents, canvassing witnesses, examining the physical scene, collecting evidence from a vehicle, and attempting to establish whether any similar incidents had occurred in the area recently. What they found did not fit the template of a random attack. The physical evidence at the scene was consistent with a targeted encounter rather than an opportunistic crime. There were no signs of robbery. Sarah's personal belongings remained in the vehicle. Nothing of material value had been taken. For investigators experienced in distinguishing between crimes of opportunity and crimes of intent, this was significant. The witness testimony from Sarah's children, obtained carefully through professionals trained to work with young trauma survivors, provided details about the man who had approached the car. Those details were specific enough to be useful. They described a man whose appearance and behavior did not suggest someone acting impulsively. He had arrived. He had acted. He had left. As Cobb County investigators dug deeper into Sarah's life in the months preceding her death, a more complex picture emerged. Sarah had, according to multiple sources, been increasingly concerned about her husband's activities. She had spoken with a family law attorney. She had been gathering information. People close to her recalled conversations in which she expressed worry, not in dramatic terms, but in the careful, measured language of someone who is trying to understand something that frightens them. When investigators turned their attention to Frederick Tokars's financial and professional world, they encountered a maze. Tokars had legal clients with documented connections to drug trafficking operations. His name appeared in financial structures, businesses, accounts, transactions that, examined closely, raised serious questions about the origin of the money moving through them. Federal agencies, including the IRS and eventually the FBI, were pulled into the investigation as the scope of what Tokars had allegedly been doing became clearer. Here is the critical turning point. Eddie Lawrence did not disappear successfully. Lawrence was identified as a suspect through the investigative work of multiple agencies combining information, physical descriptions, known associates, and intelligence gathered through the overlapping criminal networks that Tokars had been operating within. Lawrence had a history. He was findable. And when he was found, he faced a choice. He chose to talk. Lawrence's account, given to investigators and later elaborated in legal proceedings, described the arrangement that had led to Sarah Tokars's death in direct, operational terms. He stated that he had been contracted to carry out the killing. He named Frederick Tokars as the person behind that contract. He described communications arrangements and the specific circumstances of how the plan had been set in motion. This was not the only evidence against Tokars, but it was among the most direct. Simultaneously, federal investigators were building a separate but increasingly intersecting case around Tokars's money laundering activities. The nightclub businesses that had allegedly been used as vehicles for laundering drug proceeds were examined in detail. Financial records were subpoenaed. Associates were interviewed. Informants within the criminal network provided information that corroborated the broader picture of what Tokars had been doing. What emerged was a portrait of a man who had operated with extraordinary compartmentalization for years, the respectable attorney on one side, the criminal facilitator on the other, and who had come to believe, fatally, that Sarah's knowledge of his activities represented a threat he could not manage through any other means. Sarah had been consulting a divorce attorney. In Georgia, divorce proceedings carry financial disclosure requirements. Frederick Tokars, according to the prosecution's theory of the case, believed that a divorce would surface financial information he could not afford to have examined. His assets, the sources of his income, the business structures he had built. All of it would be vulnerable to scrutiny in a contested divorce proceeding. The investigation also brought into focus the particular cruelty of the planning involved. Sarah's sons had been in that car. The fact that two small children were present when their mother was killed was not incidental. Investigators and prosecutors noted this in their assessment of what the crime revealed about the degree of calculation and the degree of moral detachment involved. The federal and state investigations converged. Grand jury proceedings were initiated. Frederick Tokars, who had spent his career on the side of the defense table, was now the subject of an indictment. He attempted to flee. In January 1993, weeks after Sarah's death and as the net around him tightened, Tokars was apprehended in Florida. He had his sons with him. He was taken into custody. The image of a man who had navigated the American legal system for his entire professional life, now facing it as a defendant, was not lost on the people who had known him. The investigation had done what good investigations are supposed to do. It had followed the evidence past the comfortable explanation, past the easy narrative, and into the uncomfortable truth. The legal proceedings that followed Sarah Tokars's death were extensive and unfolded across both state and federal jurisdictions. Eddie Lawrence was prosecuted for the murder of Sarah Tokars. He was convicted and sentenced to life in prison. His cooperation with investigators shaped the evidentiary record significantly, and his testimony became a central element of the case against Frederick Tokars. Frederick Tokars faced prosecution on multiple fronts. In Georgia State Court, he was tried for the murder of his wife. In federal court, he faced charges related to his money laundering activities and his role in the criminal enterprise he had been running. The federal case alone involved charges that carried substantial prison time. The state murder trial resulted in conviction. Frederick Tokars was found guilty of murder and sentenced to life in prison without the possibility of parole. The federal convictions added additional sentences. He would never again be a free man. He died in federal prison on June 8, 2020. He was 65 years old. Sarah Tokars's sons, the two boys who had been in the back seat of that car on the night their mother was killed, grew up in the care of Sarah's family. Her parents and siblings in Ohio took on the role of raising Rick and Andy. The Ambrusco family, who had pushed from the beginning for a thorough investigation, ensured that the boys were surrounded by people who had genuinely loved their mother. What became of those boys is, in a meaningful sense, private. They lived through something that should never have touched them, and they deserve to do the rebuilding of their lives away from cameras and public attention. What is documented is that Sarah's family fought for them, in court, in custody proceedings, and in every practical sense, from the moment Frederick Tokars was taken into custody. The case had a significant impact on public discussion around the vulnerability of people, particularly spouses, who discover criminal activity within their own households. Sarah had begun taking steps to protect herself. She had sought legal advice. She had been gathering information, and yet the system had not been able to protect her in time. Her case is studied in the context of discussions about domestic violence, financial control in relationships, and the warning signs that, in retrospect, can be clearly identified but are often difficult to act upon quickly enough. Within the legal community in Georgia, the Tokars case became a reference point for the particular danger of someone with insider knowledge of law enforcement and legal procedure using that knowledge to evade accountability. Frederick Tokars knew how investigations worked. He knew how evidence was gathered. He knew, better than most, how to stay on the right side of a visible line while operating illegally on the other side of it. That he was ultimately caught was the result of investigative persistence, cooperative effort across multiple agencies, and, critically, the willingness of people who knew things to eventually say them aloud. Sarah Tokars was 33 years old when she died. She was a mother. She was someone who made rooms feel warmer. She was a woman in the process of trying to find a safer path forward, and she was killed before she could reach it. The story of this case is sometimes told as the story of a fall from grace, the lawyer who became a criminal, the professional who destroyed himself. But that framing misplaces the center of gravity. The real story belongs to Sarah, to a woman who suspected the truth, who had the courage to start asking questions, and who deserved far more time than she was given. She never got to see her sons grow up. She never got to finish what she had started. But her family made sure the truth followed the man who tried to bury it, all the way to the end. He had survived heartbreak, crossed an ocean for love, and was planning to go home. And then, in the middle of the night, none of it mattered anymore. The call came in at 3:01 in the morning. A man's voice. Calm. Almost unnervingly so. He told the 911 dispatcher that his son-in-law was injured, that there had been some kind of fight, that he may have killed him. Paramedics arrived at Panther Creek Court in Walburg, North Carolina, to find a woman attempting to carry out CPR on a man who had suffered traumatic injuries. He was 39 years old, the father of 2 young children, a man who, by every account from the people who loved him, was one of the kindest people they had ever known. The 911 call lasted nearly 14 minutes. Throughout it, the man on the line, a former FBI agent, never once lost composure. Emergency call dispatcher Karen Capps, who had worked as an emergency call dispatcher for 16 years, later testified that Thomas Martins seemed surprisingly calm throughout the call. Although he had allegedly performed over 400 exhausting CPR chest compressions, he was not panting or gasping out of breath. Jason Corbett was pronounced dead shortly after. And that is when this case, already extraordinary, became something else entirely. Later in this story, you will learn what investigators found at the scene that did not add up. You will learn about secret legal consultations made years before this night. You will learn why a judge would describe one of the people in that room as having a deranged entitlement. And you will learn what Jason's own daughter said publicly the day his killers walked free. But first, you need to understand who Jason Corbett actually was. Because before you can understand what was taken from him, you have to understand what he had built, what he had survived, and how far from home he was when it all ended. Don't close this video. The most important parts are still ahead. Jason Corbett was born in Ireland on February 12, 1976, just minutes after his twin brother Wayne. He was the youngest child in a family of 8. His parents were Rita and John Corbett. Growing up in Colbert Park in Janesboro, his beginning in life was in stark contrast to the brutal end he would meet thousands of miles away from home. He attended St. Kieran's National School in Galvone and later St. Enda's Secondary School, went on to study business management, and eventually found steady employment at Multi-Packaging Solutions in Raheen, Limerick. Jason worked his way from the bottom up in Multi-Packaging Solutions for about 15 years in Limerick. He loved Limerick and rugby and golf and all his friends in the city, and had always vowed to return to his native soil. His sister Tracy would later describe him as a great leader and inspiring, someone who took time with people, who empathized, who believed in those around him. In the 1990s, Jason met Margaret Maggs Fitzpatrick. Quotes from the family describe Maggs as his soulmate and love of his life. They built a life together in Limerick, and in 2006, they welcomed a daughter, Sarah. Their son Jack had come before her. And then, in November 2006, just weeks after Sarah was born, Mag's died unexpectedly after suffering an asthma attack. Mag's sister Catherine, who was present at the Corbett house on the night she fell ill, witnessed Mag's urgently using her prescribed salbutamol inhaler, and thereafter helped Jason carry her to his car before he rushed off to seek medical attention at University Hospital Limerick. Jason was a widower with 2 young children and a grief that ran very deep. He kept working. He kept parenting. He kept going. In April 2008, Corbett hired 24-year-old Knoxville, Tennessee native Molly Martins to work as an au pair for the family. Her father, Thomas Martins, was a former FBI agent. Molly had moved to Ireland looking for a fresh start. She came to look after Jack and Sarah. She became part of the household. And then she became more than that. Within weeks, according to later court documents, she and Jason had begun a romantic relationship. After the family moved to Lexington, North Carolina, in April 2011, Corbett and Martins married. They moved into a house at Panther Creek Court in Walbug, North Carolina. Jason paid $390,000 for the house, which was bought with the proceeds from the sale of his home in Limerick combined with his life savings. He thereafter gave Molly $80,000 to buy furnishings for it, as well as buying her a BMW SUV. Jason had also previously given his father-in-law Tom Martins $49,000 as a contribution toward his wedding ceremony. To his Limerick family, to his mother, his siblings, his late wife's parents, the distance was already painful. But they trusted Jason. They knew who he was. What none of them fully knew yet was what was building, very quietly, behind the doors of that house on Panther Creek Court. Corbett's older brother John later said the issue around Martins adopting the children had caused friction in their relationship in the run-up to his death. John Corbett also stated that Jason had specifically processed the children's legal residence status via his job, rather than through the Martins family, due to concerns they would not be repatriated to Ireland in the event of his unexpected death. Although Molly Martins had allegedly wanted to formally adopt Corbett's children so they could acquire American citizenship, Corbett instead applied for green cards while retaining his family's Irish passports. Corbett had also apparently planned to one day return to Ireland and open a pizza restaurant at Spanish Point, County Clare. It was a small, quiet act of planning, one that only makes complete sense in hindsight. In the summer of 2015, those close to Jason sensed the marriage was fracturing. At a party just days before his death, Jason left early. His family believed that this was the straw that broke the camel's back in their relationship, and that he was planning to return to Ireland without Molly. He never got the chance to tell them. The night of August 1st, 2015 started quietly. That afternoon, Jason spent time with neighbors Jeff and Christine Fritz J. According to Fritz J., Corbett had consumed 7 beers, was in good humor, and did not appear to be drunk when they parted company. Toxicological testing on Corbett's body recorded a blood alcohol concentration of 20 milligrams of alcohol per 100 milliliters of blood, a quarter of the legal driving limit in North Carolina. He was, by any clinical measure, sober. Their wives joined them an hour later, and they continued drinking until about 8 p.m. when Molly's parents arrived for a surprise weekend visit. Thomas Martins and his wife joined the household for the evening. By later accounts, the night passed without confrontation. At some point, everyone went to bed. In the early hours of August 2nd, 2015, paramedics were called to the home. At 3:01 a.m., Thomas Martins placed a call to 911. His words to the dispatcher were measured and deliberate. "My son-in-law got in a fight with my daughter. I intervened, and he's in bad shape. We need help." When the dispatcher asked for more detail, Thomas Martins said, "He's bleeding all over, and I may have killed him." When paramedics arrived, they found Jason Corbett on the floor of the master bedroom. Molly was performing CPR, counting compressions aloud. She informed first responders she was certified in the technique. The account given by both Thomas and Molly Martins that night, and maintained afterward, was that Thomas had been awoken by sounds of a disturbance from the master bedroom. He entered to find Jason choking Molly. To defend his daughter, he reached for a baseball bat that was in the room and struck Jason with it. Tom Martins beat Corbett with a baseball bat, and his daughter struck him with a concrete landscaping brick. Jason Corbett was transported to Wake Forest Baptist Medical Center and pronounced dead. The cause of death, confirmed by the medical examiner, was blunt force head trauma. What the examination of the scene began to reveal over the following hours would complicate the self-defense account considerably. District Attorney Alan Martin described to the jury how Corbett had such serious head injuries that his autopsy could not determine exactly how many times he was struck. The injuries were described in court proceedings as catastrophic. And yet, neither Molly Martins nor Thomas Martins had sustained significant injuries. Nothing at the scene was physically consistent with a man who had been actively attacking someone when he was struck. Investigating officers were uncertain about Molly and Thomas Martin's accounts because neither of them had suffered any injuries. Dispatcher Karen Capps later testified that despite Thomas Martin's claim to have performed over 400 CPR chest compressions, an exhausting physical effort, his voice remained completely steady throughout the 14-minute call. No heavy breathing. No audible distress. Jason's children, Jack and Sarah, were in the house that night. The full weight of what they had heard, and what they would subsequently be asked about, would ripple through every legal phase of this case for nearly a decade. In the days that followed, the Davidson County Sheriff's Office was not treating this as a routine domestic incident. They were looking at a homicide, and the questions they were asking were only getting harder to answer. Investigators moved quickly, and the physical evidence immediately deepened their concern. A self-defense scenario involving a single, reactive strike is one thing. What the crime scene reflected was categorically different. A sustained level of force that pathologists would later testify went far beyond anything a perceived threat could have warranted. The inability of the autopsy to establish a precise blow count was not a technicality. It was a finding, and investigators treated it as one. Blood spatter analyst Dr. Stuart James was brought in to examine the physical evidence. His analysis, he testified, was inconsistent with the account given by the Martins. The fact that Dr. Stuart James had not physically visited the crime scene was cited by the defense as a reason to discount his testimony regarding blood spatter. The prosecution nonetheless stood by the substance of his conclusions. The investigation then turned to everything that had happened before August 2nd. Court records later revealed Martins had, in the summer of 2013, sought legal advice on her custody rights regarding the children in the event of a divorce, and had also spoken with a lawyer in late 2014 about her rights to the children. Neither consultation was known to Jason. Neither was disclosed to him. The children were, by every legal and practical measure, the central issue. Molly had wanted to formally adopt Jack and Sarah. Jason had refused. She could not become their legal mother without his consent. And if Jason were to leave the marriage or bring the children back to Ireland, Molly Martins would have had no legal claim to them whatsoever. Multiple witnesses would later confirm that Jason and Molly had tried to start a family of their own, with Jason even spending $25,000 on fertility treatments for Molly without success. Martins would later allege to her neighbor that she had suffered 6 miscarriages in the 7 years she and Jason had been trying for a baby. The inability to start a family of her own, combined with Jason's steadfast refusal to extend her legal claim over his existing children, had become an increasingly contested reality. Investigators did not speculate about what this meant. What the documented evidence established was a clear, years-long pattern of Molly Martins seeking legal guidance on how to retain the children in the event of separation, and a clear understanding that Jason himself was the only obstacle to that outcome. In the immediate aftermath of his death, social services in Davidson County had initially placed Jack and Sarah in Molly's custody. The Corbett family in Ireland responded immediately. Jason's sister Tracy Lynch flew to the United States and filed a legal challenge. On August 20, 2015, the authorities dismissed Martin's claim and handed Jack and Sarah into the custody of Tracy Lynch, who promptly flew the 2 children back to Ireland. Judge Brian Shipwash, who presided over the guardianship hearing, would later remark that Martins had a deranged entitlement to the children, that he was shocked the Department of Social Services had originally placed them in her custody after Jason's death, and that his primary concern was to return the children to Ireland as soon as possible. On August 26, 2015, after a funeral service at Our Lady Queen of Peace Church in Limerick, Jason Corbett was laid to rest beside his first wife Margaret Maggs Fitzpatrick at Castlemongret Cemetery. Two families, Corbett and Fitzpatrick, stood together at the graveside, separated by years and now by tragedy, but holding the same grief. The criminal case built steadily through 2016. Both Thomas and Molly Martins were charged with second-degree murder. One of the most significant pre-trial battles centered on the children's statements. In the period immediately following Jason's death, Jack Corbett had given statements to American social workers in which he described his father as physically abusive toward Molly. These statements were later recanted. During pre-trial hearings, Tracy Lynch testified that once she brought Jack Corbett back to Ireland, he informed her that some of the information he gave in previous interviews with U.S. social workers was untrue. He had been afraid of where he would be sent. The trial court found that the children's statements were not made at a time when they were motivated to speak the truth, but were rather motivated to affect future custody arrangements. The children appeared to have known that if they were not in the custody of Molly Corbett, they would be taken to live in Ireland with relatives of their father. The statements were ruled inadmissible. The trial of Molly and Thomas Martins began with jury selection on July 17, 2017 at the Davidson County Superior Court in Lexington, North Carolina, before Judge David Lee. Both accused entered formal pleas of not guilty to the second-degree murder of Jason Corbett, claiming they acted in self-defense. The prosecution argued that the weapons used, two of them applied with sustained and devastating force, were not consistent with a panicked, reactive intervention. They contended the concrete landscaping brick had to have been deliberately brought into that room. The level of injury inflicted on a man who showed no significant defensive wounds by two people who emerged from the encounter physically unscathed was not consistent with self-defense. It was, they argued, a deliberate attack. The defense team asserted that the prosecution had failed to illustrate an element of malice, a fundamental component in proving a second-degree murder charge under North Carolina state law. There was also no evidence of flight bookings to support the allegation that Corbett was planning to return to Ireland, they added. They argued for acquittal. The jury deliberated. Then it decided. On August 8, 2017, the jury returned its verdict. Molly Martins and her father, Tom Martins, were found guilty of second-degree murder in August 2017 for the killing of Corbett. They were both sentenced to between 20 and 25 years in prison. In Limerick, Ireland, the Corbett family received the news with relief. In Davidson County, it appeared the legal chapter of this case was finally closed. It was not. Their 2017 second-degree murder conviction was overturned on appeal in 2020, and the retrial was moved from Davidson to Forsyth County due to the intensity of the media and public interest in the story. The appeals court determined that the exclusion of the children's statements had constituted a reversible legal error. A retrial was ordered. The retrial loomed through 2021 and 2022. Then, in October 2023, before a second jury was ever seated, both Thomas and Molly Martins accepted plea agreements. Before the retrial began, the Martins' father and daughter accepted a plea deal for voluntary manslaughter in October 2023. The district attorney dropped the murder charges, but Judge David Hall advised them that a no-contest admission under North Carolina law was taken to be an admission of a guilty plea. Under the deal, Tom Martins admitted hitting Corbett on the head with a metal baseball bat, and his daughter admitted striking him on the head or shoulder with a concrete landscaping brick. The plea agreement stated that the autopsy and circumstances of the scene establish that at least some of the fatal blows inflicted were of a nature, number, and level of force that exceeded what could have been justified as self-defense. After appealing their conviction and being granted a retrial, Molly Corbett and Thomas Martins were sentenced to a minimum of 51 months in prison with credit for time served. Both were released from prison on June 6, 2024. Their one-year parole period was officially terminated on June 6, 2025. During that time, Tom Martins and his daughter Molly were subject to strict conditions. including where they could live and travel. Neither came to the attention of authorities during this period, meaning they can now move freely within the United States and live together in the family home. On the day of their release, Jason's daughter Sarah Corbett published a statement. She was composed. She was direct. Sarah said, "This sentence disappoints me. I'm doing the best I can, but I feel let down and disappointed by any outcome where the Martins are released back into society. It feels unjust that they weren't brought before a jury of their peers. I am confident they would have been found guilty, evident by their acceptance of the plea deal." She continued, "Molly Martins manipulated my love, trust, and feelings from a very young age for her own gain. The Martins chose self-interest over considering the harm caused to innocent individuals, especially children. But I am no longer a child that can be manipulated. I aim to prevent such situations from happening again." There is no legislation bearing Jason Corbett's name, no national reform that emerged directly from his case. What was left behind is quieter than that, and in some ways more lasting. A plaque was erected outside the plant on the 2nd anniversary of his death. It was draped with an Irish flag and etched with the words Kona's attitude, "How are you?" A nod to Jason's love of Irish, which he tried to impart to his American colleagues. He never opened that pizza restaurant at Spanish Point in County Clare. He never brought Jack home for secondary school in Limerick, as he had hoped. He never made it back to Irish soil alive, only in August 2015, carried home in a casket to Castlemongret Cemetery to rest beside Mags. His children carried themselves out of that house and into adulthood with something intact that no courtroom outcome could touch: the knowledge of exactly who their father was. They speak, they advocate, they remember. And the families Corbett and Fitzpatrick remain bound together across the Atlantic, still holding vigil for a man who crossed an ocean with grief in his past and love in his plans, who worked hard and gave generously and asked only to bring his children home. The legal process has run its course. The parole records are updated. The world has moved on in the way the world always does. But some questions don't close when the paperwork does. Jason Corbett was 39 years old. He had survived the unsurvivable. He had rebuilt his life with patience and love in a country that was never quite his own, for children who needed him to hold it together long enough to bring them home. He almost made it. The script hits every structural requirement in sequence and stays within your word count window. A few craft notes on the decisions made. The opening line leads with survival and journey rather than violence. It creates emotional stakes before the viewer knows anything. The retention hook drops straight into the 911 call, the single most chilling documented fact in the case, the calmness, and plants 4 forward teases without spoiling anything.